So welcome back. The next item on our agenda is a presentation by Gary Lauder, who is immediately here to my left. Gary is the managing director of Lauder Partners, LLC, a Silicon Valley-based venture capital firm. He's been a VC since 1985, investing in over 100 private companies. In the 1980s, he worked at two venture firms here in New York City. He holds a BA in International Relations from the University of Pennsylvania. He has a BS in Econ from Wharton and an MBA from Stanford. He is the co-creator of the Aspen Institute's Socrates Society with Laura, his wife. He is co-inventor of 16 patents and has owned two companies that defended 3 NPE cases. He is, and has been for more than a decade, an advocate for the entrepreneur's side of the patent debate. So, Gary, thanks for joining us.
Thank you, David. So it's quite an honor. I will try to share some perspectives that will strive to be novel, useful, and non-obvious. Since one can read much faster than listen, and you can listen faster than most people speak, and since spare mental cycles lead to multitasking, which leads to lower retention, I'll try to use up those spare cycles and rely on that Doppler effect, which is the tendency of stupid ideas to seem smarter when they come at you rapidly. So as you mentioned, I'm a VC. I've invested in over $500 million in the past 32 years, and over 100 companies, over 70 venture funds. I'm not a lawyer, but I've kept many well fed, and I have inventor or co-inventor in 16 issued patents, and have no interest in any troll, PAE, or entity behaving as such. And since this is being recorded, I may define acronyms that you all already know. So PAE is Patent Assertion Entity. My expertise is in how VCs consider what to invest in and the role that patents play in that, and how patents affect the success of small companies. Patents don't matter much to software and internet companies, but they do to most other technologies. And the National Venture Capital Association board has software and internet types still has, who didn't like patents. And so the NVCA was mild in its criticism of prior bills up to 2014, but after that it has gotten religion, fortunately. I'm no fan of PAEs, and as mentioned, I was chairman of two companies until 2015 when I sold them, and within the prior 3 years, both had been challenged 3 times by PAEs. Incidentally, none of my companies prior to that date had ever had such a challenge, so it's a relatively rare thing in my experience. I fought all 3, didn't settle with any of them, and won all cases, and average cost was about $100,000. Despite that experience, I believe that anti-troll bills that have been considered and probably inevitably will be proposed in the future would be more harmful than helpful to legitimate patentees, in that it would make it harder to fund the startups that need patents because it would make it harder for them to win cases. It's an existential threat to them. And much of PAE activity is just and fair, which I'll get to later. So there is a false premise, and this is not news to many, that all trolls are bad. And so let me give you an example of a just PAE from my own experience from a while back. In 1994, I invested in a company named Hybrid Networks. They were the inventor of asymmetrical cable modems. Cable industry created the DOCSIS cable modem standard, which incorporated some of their technology. That company moved to wireless modems, but ultimately it failed. Now all cable modems are asymmetrical, and the assets of the company went to the debtors, and then the debtors sold the IP to a PAE who sued large MSOs, which are multiple system operators, which is what we call large cable operators. They offered over $100 million to settle, but the PAE declined. It went to trial in the Eastern District of Texas, and the PAE lost, which is surprising, but whatever. So the result is that the thieves won. And note, I had no interest in the outcome since it went to the debtors, who had only lent $5 million initially. But anyway, in retrospective, this is illuminating for a few reasons. Firstly, I knew that this would be a huge market before I went into it, and that there was a risk of IP theft, but I was induced to invest based in part on the faith in the patents as a backstop of value. And so did Axel and Sequoia, two very successful venture firms. And lenders lent to the company based on knowing that the patents should have some residual value. And for those patents to have full value, they needed to be sellable to a third party, by definition a PAE. And venture capitalists are not in the business of funding lawsuits, and it's really hard for them to fund lawsuits, especially when they're against major corporations, because, for example, we've got many companies in our portfolio, some of which want to sell to these guys, and so if you can't be suing them and trying to sell to them at the same time because they'll exert pressure through you. So it's really not a practical thing for a venture firm to be funding these things. Now, many patent bill considerations in the past have tried to demote the value of patents if they get transferred, and I mean which is basically ludicrous from if you understand how the system operates in a functional way today. So and if one had to be a practicing entity, they could have continued to make a few modems to perhaps qualify. But anyway, so fairness. So the cable industry's cash flow from cable modems, which is their primary business today, is over $30 billion per year. If they had won and the entire industry, say, paid $200 million, the cable industry still would have been the big winner. The company was forced from practicing to non-practicing due to that theft. And I would not have made the investment if the patent regime had been what it is now becoming. So if the cable industry was punished for theft, that might have led to better behavior. So I should pause to give a bit of a taxonomy of trolls and PAEs, and they're not all equal. So I'd call the prior example a just and fair PAE. They're socially useful to punish offenders, as I mentioned. And examples would be Edison, Dolby Labs, universities, and government labs. They're all non-practicing entities. And the term trolls should only be used for nuisance suits, those who are looking to settle for less in litigation because they don't think they could win in litigation, either because the patents aren't very good or they don't really apply to what the defendant is doing, or for a whole host of reasons people misuse those. And that's bad behavior that can be also punished through the courts. And the lowest form of life is the letter mills who try to, send letters to lots of people who are using fax machine scanners, Wi-Fi, et cetera, in the hope of getting like $1,000 from people who are afraid. And that's actually a very minor issue that has gotten a lot of play. And if everyone simply says you can safely ignore them, then they would go away. So that's really shouldn't be so much of an issue. But they're not all the same, but they're tarred with the same pejorative brush. And it's worth mentioning, not all startups need patents. So since the PTO takes over 3 years to issue, which is too slow for many types of business, especially software and internet businesses, which have other challenges with getting patents too, especially post-Alice, they are needed for many innovations that are easy to copy once the pioneers show the way. For example, medical devices and biotech, energy and clean tech, Internet of Things, semiconductors, electronics, optics. In one area of optics, LiDAR is very important today since that is what they are needed for automated vehicles. And in fact, the lawsuit between Google and Uber is about the theft of Google's LiDAR technology. So most tangible things, and there are others that are miscellaneous and yet to be invented. So there are so many things that do need patents, and were we to further reduce the strength of the patent regime, many of these things will ultimately not get funded. And on balance, our society is not likely to know that they're missing, although since China is creating a stronger patent regime than ours, we'll know that they're missing because they're happening there. Anyway, so it turns out that incumbents like incumbency. Joseph Schumpeter coined the phrase creative destruction, and that was describing how new technology, usually from new entrants and new companies, new players, and how they swept away old and therefore improved things. Well, lo and behold, the incumbents don't like the destruction part of that phrase, and patents are hugely important for this, but their importance, alas, is declining. And some industries are net defendant. They don't use patents to achieve market power, and often they don't invent much. So software and internet companies like Google, Oracle, Salesforce, et cetera, who, by the way, are all members of the High-Tech Inventors Alliance, which is quite ironic, which is a lobbying organization to further weaken the patent system. Intel has patents, but their historical market power comes from huge economies of scale. So, for example, the latest wafer fab that Intel is building will cost over $8 billion. There are very few parties that can afford to invest that much to make a fab, and therefore that tends to protect them competitively, although I allege that things are going to change. And when Apple, who's making their own chips, starts to pull into their chips some of the IP of Intel will regret their role in undermining the system. We'll get to that later. So banks got sued for using infringing image-based check processing technologies, so they also lobbied for the AAA. And big consumer electronic companies, where most of the innovations in the semiconductors and there's virtually no margin for R&D, they don't like patents, and so they're largely members of the Consumer Technology Association, formerly known as the Consumer Electronics Association, who have been some of the biggest, loudest mouths regarding how awful trolls are, and I'll get to that later also. Restaurants and retailers and so forth, they are all among the people who don't like patents. Cable and telephone companies, their market power is mostly geographic, and so they too don't need patents. So there's an unholy alliance among all these folks who have come together to, quote, fix the troll problem. So they parade poor innocent victims of trolling, usually small companies, which fools Congress into sympathizing with them. The victims are not the ones who have paid over $1 billion so far to lobby this issue over the past decade. That's right, over $1 billion has been spent lobbying against, quote, patent trolls or patent problems in Washington over the past decade. So trolls are the necessary boogeyman to trick Congress. And so as part of that, you need to objectify to get people to lose their rationality. Of course, they create all these awful images of patent trolls, and there are quite a lot of them, actually. And the one good thing I can say about these people is that at least they support artists and respect copyrights. Otherwise, they would have used the same image over and over again. So, or do they? So there's one and there's another. Different artists, but you can definitely there was some copying there. Anyway, so and even Stanford co-sponsored a conference with Samsung, and where they had their own troll image. Patent trolls and patent reform is the name of the conference, and the fine print there is the troll is stomping on the word innovation. John Hennessy, Stanford's former president, who was the president at the time of this conference, is on the boards of Cisco and Google. Coincidence? Maybe. Or it couldn't be that Mark Lemley is there, but whatever. So they've been sponsoring a publicity campaign that people in Shrek costumes handing out flyers outside of Union Station in D.C. This was around the time of the Innovation Act, and this was sponsored by the CTA. Posters on the walls of the National Airport. You can be sure that those were not paid for by the small, innocent victims of trolls. And the CTA's membership is mostly companies like Samsung and other foreign companies that don't really do a whole lot of innovating themselves. So, sorry, Samsung does, but most of their membership, I think, does not. Anyway, it's been willfully blown out of proportion. So our divider-in-chief once said, I have the best words, and here's a good one for you. Sophistry, the use of fallacious arguments, especially with the intention of deceiving. It really describes the lobbying around this issue quite well. Here is a screenshot of a page from the White House's 2013 PAE report, and it shows the hockey stick growth of patent lawsuits. This is a time series from 2006 to 2012. That hockey stick is actually a deception. The problem willfully overstated because the growth in litigation cases was due to the AAA because it had an elimination of joinder which was meant to harm trolls by requiring that suits against multiple defendants be filed separately. And so the number of suits went up, but the number of defendants did not. And so the number of litigants is the smallest since 2009. And the White House report's authors knew this and withheld that information. So I would say that's willful deception. And so here is a graph from Lex Machina from 2008 to 2016 of the defendant case pairs. So this makes an apples-to-apples comparison between before and after the AAA. That spike in the middle was due to the AAA, and shows that the number of defendants is actually flat over that time frame. So the out-of-control problem is, in fact, one big fat lie. So for some reason, this has not made it into the mainstream press, but more on that later. So and this is a longer-term perspective. This is patent suits as a fraction of all civil suits in the district courts from 1923 to 2013. And so you can see that from the 1920s to the 1940s, it was a percentage of total suits filed got as high as 3.7%. And then it declined a great deal and has stayed low to the present. And the spike at the end is the same thing we just discussed, so it's not real. This shows IP lawsuits per $1 billion of GDP. And again, you can see that patent lawsuits have really stayed fairly constant over that time frame per GDP. And the other colored graphs are copyright lawsuits and trademark lawsuits. So again, the problem is not out of control, unlike what they would like you to believe. So actually, measuring litigation is the wrong measure. And one of my favorite quotations is from Albert Einstein, which is, not everything that counts can be counted, and not everything that can be counted counts. And what's most important about the patent system is inducing the right behavior without litigation. And litigation is just the stick to induce it. And part of that is the behavior of getting entrepreneurs and investors to take startup risks and getting incumbents to buy innovators and not copy them or license them. The right behaviors don't show up in the statistics because litigation is the tip of the iceberg, but what's much bigger and much more important is the corporate behavior, and that is hidden below the proverbial waterline. Anyway, so the disrespect for patents is growing. There's unabashed copying, also known as efficient infringement. And another quotation that is so true. When people are free to do as they please, they usually imitate each other. So large companies are ignoring innovators more, or sorry, I shouldn't say ignoring them. They're paying close attention to what they do in order to copy them, but they are not giving them the appropriate respect by making deals with them. And that is largely a result of the growing difficulties in enforcement. There's a better chance of a defendant winning, and there are many new ways to delay the outcome through PTAB and others. And infringers are emboldened by the constant chipping away at the probability of the plaintiff's success. And the Supreme Court is chipping away at that too. So the NPE problem has been, as I said, willfully overstated. Here's part 2 of that. There's some academics at Boston University named Besson and Moore who did a study that is frequently cited as saying the annual cost of trolls is $29 billion. This work and much of their previous work has been discredited and debunked and trashed and so forth. And they looked at the change in market capitalization when a suit was started, but they never looked at what had happened later when the suit was adjudicated. And there are many, many other problems with their studies. This report was also cited by the White House and by many other people, and it's still being cited to this day. And the General Accounting Office's study of the issue did not find a PAE problem, although no reporter seemed to have found the GAO study. And the misinformation echo chamber continues. So Churchill once said, "A lie gets halfway around the world before the truth has a chance to get its pants on." And, the mainstream press reads other mainstream press, and that's what educates them. And so do most people, and perhaps Supreme Court clerks too. So I am conducting a search for terrestrial intelligence in the mainstream media. So anyway, so trolls are a problem, but it's hard to legally distinguish them from the righteous type, and universities and Edison, Dolby, et cetera. Legislation should target behavior rather than the character of the party suing. And the problem, as I said, has been willfully overstated. The rise in litigation has other causes. I mentioned that. Patent trolling is not new. In the 1800s, they were called patent sharks, and there have been several SCOTUS rulings that have been, that means Supreme Court, for those who don't know, which have been troll setbacks. And also the Judicial Conference amended the rules to eliminate Form 18, which raises the pleading requirements. And there's also an interesting correlation, which has not really been talked about since the America Invents Act, which is that the more expertise people have in the patent field, the more they are against more patent reform. In other words, they recognize patent reform is a bad thing, but the correlation with expertise is yet to be publicly made. So Congress seems, unfortunately, to be the wrong way to make sausage. And by comparison, the 1952 Patent Act, it was written by 2 experts over 4 years. And one was Pascal Federico, the chief patent examiner of the PTO, and Giles Rich, who's a patent lawyer and later patent judge, went to Harvard, smart guy. They had no vested interests or conflicts that we know of. They passed both houses without debate. They deferred to the experts and had reason to trust them. It was simple and clear, 35 pages. It led to huge success. Compare that to the American Invents Act, which was, I think, 135 pages written by lobbyists and staffers, non-experts with vested interests, long, complicated, ambiguous. It excluded the interests of startups, and it was written by... So staffers are mostly dilettantes with little time, and many are looking to join lobbying firms that are lobbying them right afterwards. I know of at least one that joined Intel shortly afterwards. And legislators themselves are even less equipped to address this. And so there are provisions that are snuck in that few even realize. So in an innocuous one in the Innovation Act, which unfortunately did not pass, was to eliminate Section 275, Title 35, striking subsection F. What did that do? That would protect a guilty infringer who is using an unreasonable defense from the possibility of a fee reversal. In other words, they wouldn't have to pay for the plaintiff's legal fees if they were lying. No, anyway, I could go on. So when litigants can mutually anticipate what courts would decide, then settlement is more likely. And this is a really important point. A lot of people sold the AAA by claiming it would have higher certainty. Well, actually the opposite has been true. And so the more uncertainty, the more likely people are to litigate because each side naturally has overconfidence and then they think that suing is a better outcome. You know what, there's so many ambiguities in the AAA. I will, let me just touch on one. What the terms otherwise available to the public or disclosure mean. They must mean different things, otherwise they wouldn't need to use those two different terms. Same thing for subject matter disclosed and claimed invention. So anyway, attempts to fix problems from the AA would probably make it worse. So most problems begin as solutions to prior problems. After much thought, nobody has come up with a perfectly just patent system, and I can't think of one. And so the question then becomes, to whom should we allocate the injustice? And my answer is away from the precious, fragile, and valuable thing we have in America, which is the startup ecosystem, and to the large infringers whose expenses might rise by 25 basis points, which is 0.25%, which is a tiny dent in their profitability. So I have postulated a way to think about this, an ISO injustice curve. So on one axis is the injustice that's allocated to the defendant, and the other is injustice allocated to the plaintiff. And so the Innovation Act, which did not pass, it would have shifted injustice from the defendant to the plaintiff, the inventor, which I think is not a socially useful trade-off. So what we should seek is to have less total injustice and to move off the curve or move the curve, depending on how you see it. So I think it's reasonable to have a lot less injustice for the defendant if the trade-off was only a little bit more injustice for the plaintiff. But anyway, the Latin phrase qui bono means who benefits. And if your company could lobby the government to relax pollution rules such that it would harm people, then most people would consider that to be unethical. But if your company could lobby the government to lower your patent defense costs, but in doing so would prevent funding future new cures and medical devices, more people will die sooner. I think that's also unethical, or in Google speak, that's being evil. Speaking of Google, why are they so anti-patent? Well, one hypothesis is that it might be due to one of my companies that sued them in 2002. That company was named GoTo.com, which later changed its name to Overture, and they invented the paid search model. GoTo missed the filing deadline on their core IP by 1 day, and that was when the grace period was a year. It's now under the AAA, the grace period is 0. Goose egg. That's another thing that has not yet hit the fan, in my opinion. But GoTo did manage to patent a lot of their secondary stuff around their technology, and then Google copied and improved upon their technology and named it AdWords Select, and then later they dropped their original AdWords offering, and now that's just called AdWords, which is their main business model, the main cash cow of Google. In 2004, the patent suit was settled, and Google gave them 2.7 million shares, which was a lot of money, and that may have seared in their mind, boy, patents are evil. But really, I mean, actually, it's perfectly reasonable that Google pay them a lot for that, but they haven't come away with that perspective. So policy people rarely admit errors or reverse them. So, for example, Cisco lobbies to weaken patents, and lobbied for the AAA, which weakened patents, and created the PTAB, which overturned Cisco's patents in Cisco's suit against Arista, a major competitor. This is, one sows what one reaps. People's minds usually don't change, so they'll usually have to change out the people to effect change. In conclusion, the ongoing weakening of patents will be destructive of the U.S. patent-dependent startup ecosystem and venture capital. More than 10% of our GDP comes from VC-backed companies, and the weakening of patent rights takes over 20 years for effects to play out. And by then, you are likely to have been in the hospital room for yourself or a loved one wishing that someone had invented the cures that you need or they need. So I hope that this is less for the people in the room and more for the people who should be hearing this. I hope they'll take that to heart. Thank you very much.